Good morning, everyone. My name is Jeremy Herman. It's great to be with you again. Happy Friday. I'm an employment lawyer at Samfiru, Tumarkin LLP. I'm located in Toronto, Ontario. And as you know, I'm sure many of you have followed us and have been with us before for these Q&A sessions. And as you know, we host many of them in Ontario and British Columbia and Alberta. We have offices across those provinces. And really the goal of these sessions is to get your questions answered. We want to educate as many people as possible and to have you understand what your employment rights are and to pursue those rights if necessary. And we're happy to help you do that. So it's great to be with everyone again today. We're heading into holiday season. And as I usually do, I like to start off with an important topic. And generally, as I said, the focus of these sessions is on employment law questions. But I'm in Toronto, and for all the viewers in Toronto, we know that yesterday was a mess with the weather. We had freezing rain and snow, and it certainly caused a lot of delays on the roads and accidents, unfortunately. And so I thought it would be a good time to discuss what to do when you're in this situation, when you find yourself, unfortunately, in a motor vehicle accident, which is becoming more and more common, especially this time of year. And so the first thing you'd want to do is you want to gather all the evidence, right? And if you're in a position to do this, of course, sometimes, unfortunately, the person in the accident may not be able to take the time to gather the evidence. But if not you, try to have someone else in the car or a witness or whoever it might be gather important information. And so what you want to do is you want to gather the other driver's name, their license plate number, their phone number, their address, the type of car and model, and their insurance company and policy information. If there are witnesses to the accident, important that you get their names as well. And if you can, it would be ideal if you take videos or pictures of the scene. All of this is documenting what happened, and that's very important. The second thing you do is you want to make sure that you are seen medically if necessary. So if you think you've only suffered minor injuries, still important that you would go to the hospital and you get medical attention. This can be very important for your health and also for the evidentiary record of the case. And you also want to report the accident. So to the police, to a collision reporting center, to your insurance provider. Very important that you take this step. A lot of people might feel nervous to do that. They think they're getting themselves into hot water or into trouble if they report it, but that's not true. You have a duty to report it to the police, to a collision center and an insurance provider, depending on the severity of the accident. And it's very important that you do that. And lastly, contact a lawyer who's skilled with dealing with motor vehicle accidents. We have a team at our firm that is very skilled at doing that, and we have years of experience with it. So please don't hesitate to contact us about that. And you can reach us at 1-855-821-5900. So that's 1-855-821-5900. And with that, hopefully that gives you some information on how to deal with this bad weather and unfortunate accidents that occur. And now I'll jump into important employment law topics and starting with some questions here. So we have a question from Vanessa on Facebook rather. And Vanessa says, is your boss allowed to ask you why you were taking sick leave if you have a doctor's note? So that's a great question. And again, it's becoming a very important topic these days because we're dealing with COVID as we have for a while, RSV, the flu, and it's a time of year where a lot of people are getting sick. And so let's talk about what your rights are in this situation. So in Ontario, and I'll focus on Ontario because that's where I practice, you have 3 days of sick leave under our provincial legislation. And those days are unpaid, unfortunately. But you have a right to those 3 days no matter what. And it's important to note that you only qualify for those days if you've worked for your employer for at least 2 weeks consecutively. Now, recently, the federal government has extended what we call EI sickness benefits from 15 to 26 weeks. Now, this is for a person who needs longer than several days because of an illness or an injury or some other medical reason that's preventing them from working. And they would qualify for sickness benefits from the government, from employment insurance. It used to be that you would get 15 weeks. The federal government has now increased that to 26 weeks. And in this situation where an illness or an injury lasts for a long time, it could happen that you have to miss work frequently. It's not uncommon at all. And it could be difficult for you to perform your job in that situation. And it's important to note that if your illness or injury is a disability, which often it might be classified as a disability under our human rights code, then there are human rights protections involved here, and your employer has to tread very carefully. And hopefully employers know that when they're dealing with a person who potentially or definitely has a disability under the human rights code. You have to be accommodated to the point of undue hardship, which is a very high level, a very high threshold. And your employer has to ensure that you are working in an environment where you're accommodated or you have time off of work to deal with your illness or your injury. And so it comes to a point, Vanessa, to answer your question more specifically, it comes to a point where, yes, your doctor is allowed to ask for medical information. Sometimes they ask for a doctor's note and the employer doesn't feel that the doctor's note is sufficient. That's usually a problem, because if the doctor's note says that you need time off, then that's what it says, and you have that medical approval. But it is not uncommon that your boss might ask for additional information from your doctor. If that's happening to you, you should definitely reach out to us, help at employmentlawyer.ca, and we have tons of resources on this topic as well that you can find at employmentlawyer.ca. So, Vanessa, I hope that answers your question and gives you some background as well on the sick days and the benefits that you receive in Ontario. And if you have a follow-up question, Vanessa, please feel free to post it in the chat. Okay, we have a question on YouTube from Jaden. And Jaden says, I've heard your firm mention constructive dismissal and not accept changes made to your job. How quickly do you have to let your employer know that you don't want your pay to change, or can you accept it for a little while? Excellent question, Jaden. And I'm happy that you're familiar with the topics that we discussed. Constructive dismissal is a very common topic. And let's just go over that a little bit. So constructive dismissal, what that means essentially is that your employer may not be outright terminating you. They haven't said you are terminated, but what they're doing is they put you in a situation where the terms of your employment have changed substantially. A classic example of that, as Jaden mentions, is your pay has changed. So if your pay has decreased, then you can't argue that that is a constructive dismissal. Your employer is changing the terms of your employment. That effectively is dismissing you. Now, in terms of a pay cut, we don't have a hard and fast rule in the law of how much of a pay decrease is considered a constructive dismissal. But we have some decisions that have been through the courts where they've said around 15%, if not a little bit less, definitely a little more than 15%. And so if you're in that situation, absolutely you want to contact us at help@employmentlawyer.ca. You will be owed full severance, which could be up to 2 years of pay if you have been constructively terminated. For example, if you have been experiencing a pay cut. Now, Jaden, how quickly do you have to let your employer know? As quickly as possible. As quickly as possible. Again, there's no formula that says it has to be 3 days or 1 week or 2 months that you have to let them know by. However, what the law has said is it has to be fairly quickly. You can't just sit on this issue. If you sit on the issue, then your employer might have a very viable argument to say that you have acquiesced or you have condoned or consented to the pay cut. And so you definitely don't want to be in that situation. You want to inform your employer as soon as you're aware of it that you believe you've been constructively terminated, and you do not accept, very important that you say you do not accept the pay cut. And it's very important that you do this in writing, because your employer may deny it, unfortunately, if they deal with a legal issue, if they deal with a lawsuit from you. So important that you very quickly inform your employer that you are not accepting this pay cut. If you're taking a position, usually with a help of an employment lawyer, that you've been constructively terminated, you would mention that in writing as well. And then you have evidence that shows when you informed your employer about this, how quickly it was after the pay cut happened, and you have evidence that you do not accept the pay cut. So very important that you do that quickly in writing. And again, you could be owed full severance pay. And again, this is a good time to talk about what that severance pay might look like. I don't want you to not understand what I mean by full severance pay. And so first of all, we have a really cool tool called the Pocket Employment Lawyer. And part of that Pocket Employment Lawyer, we have a severance pay calculator. And the severance pay calculator will ask you very basic information, just simple information that you can provide about your age, your position, how long you worked for the company, what you were earning, and it will spit out what your severance pay will look like based on that situation. It's anonymous, it's free, it's very easy to use, and it was just on the screen. You could find it at pocketemploymentlawyer.ca and take a look at that severance pay calculator. So Jaden, I hope that answers your question. And if you have any follow-up, please feel free to ask me and post it in the chat. Okay, so we have a question on YouTube from JBK. And they ask, is there any lawsuits for being put on leave for not being vaccinated? Okay, so I believe, JBK, you mean lawsuits. Correct me if I'm wrong. And for being put on leave for not being vaccinated. Absolutely. You can find out more about this, as you see on the screen, at covidrights.ca. We have tons of resources on this topic. We have discussed it at length, and yes, we have many cases involved at our firm, and we're representing many individuals who have been terminated or put on an unpaid leave of absence as a result of their personal decision to not be vaccinated. And so please take a look at those resources. If you have a more specific question, JBK, please post it in the chat. What I can say is that we've assisted hundreds and hundreds, if not thousands, of individuals who have been terminated or put on a leave as a result of not being vaccinated. We have resolved many of those cases, and so you should absolutely contact us. Learn more about this at employmentlawyer.ca, and contact us for any more specific questions, or if you want to set up a consultation at help@employmentlawyer.ca. JBK, if you have any follow-ups, again, please post it in the chat. Okay. So we're moving on here to Sloan on Facebook. And Sloan asks, the company I work for is closing down after about 7 years of me working there. Am I owed anything if it closes down? Yes, you are owed severance pay 100%, Sloan. So if your company is shutting down, or if it's being sold or restructured, whatever the case might be, that is still considered a termination of your employment if you've been terminated as a result of the close down or the restructure. and you will be owed severance pay. Again, check out our Pocket Employment Lawyer to find out how much severance pay you are looking at. Again, it will depend, Sloan, on your age, the position you held, how much you were earning, and generally how long you worked there, of course, and generally the availability of similar employment in the job market right now. And we are, many would say we are in a recession, and so the availability of similar employment in certain industries is certainly limited. We see that in the tech industries and in the cannabis industries. There are a lot of layoffs and terminations happening, and that very likely could increase the severance pay that you would receive, Sloan. Many people would think it might decrease the severance pay because we're in difficult financial times for many employers, but actually that's not true, because severance pay does not look at the difficulty of your employer. Severance pay looks at how easily you can reemploy. And so if you're in an industry where you cannot reemploy as easily because of the recession that we're in, then you would be owed more severance pay as a result of that. So if you have more questions on this, we have resources to take a look at employmentlawyer.ca. And Sloan, if you have any follow-up questions, as I always say, post it in the chat. I'm happy to answer them. Okay, let's move on. We have a lot of questions rolling in. I'm happy to see that people are taking advantage of this time to get your questions answered live. And so we are looking at a question from Masood on YouTube. And they say, if I go back to work after finishing short-term disability, but still on medication, can my employer fire me? My employer is in the process of mass firing many people. Good question, Masood. So your employer is able to, generally speaking, let's talk generally for a minute. An employer is able to fire their employee without cause, which means they're not taking a position that you're not owed severance. Your employer agrees and acknowledges that you're owed severance pay. In that situation, your employer is allowed to terminate you. In Ontario, that is the law. What your employer cannot do is terminate you without the proper severance pay. And that happens all the time, unfortunately. And so if you are facing a without cause termination, you are owed severance pay 100%. And if there are mass terminations happening, your severance pay might look different as well, depending on how many people are considered part of a mass group that is being terminated. If you are finishing short-term disability and you're still on medication, there potentially could be a human rights issue. So a caveat to what I said before, that your employer can always terminate you if they're terminating you without cause, is that they cannot do that if there's discrimination involved. So if your employer is discriminating against you based on a protected ground, so based on your age, your disability potentially, your religion, your creed, your sexual orientation, and many other grounds that are listed in our human rights legislation in Ontario, then that would be considered discrimination, and you would potentially be facing not only severance pay, but also human rights damages as a result of that discrimination. So, Masood, it will really depend on if there is discrimination happening here. And in order to know that, I would need you to contact us, and let's set up a consultation. You can contact us at help@employmentlawyer.ca. Let me figure out more details about your situation, when you were put on short-term disability, when you finished, what kind of medications you're on, does your employer know about it? All of these are very important factors. And you could be facing a human rights violation there. And that would be certainly problematic, and you might be owed human rights damages on top of severance pay. So, Masood, I hope that answers your question. If you have a follow-up, post it in the chat, please. All right, we're moving on to a question from Mark on YouTube. And Mark says, is there anything you can do to get out of a non-compete clause in a contract? I'm very limited in my ability to find another job in my field. Mark, so good question. It will depend on the contract. I need to see it. I need to review it. I need to know when it was drafted. I need to review the specific language of the non-compete clause within the contract. It depends on your industry. There's many factors involved to assess whether this non-compete clause is enforceable or not. There's a good chance it is not enforceable. We have recent law that says non-compete clauses are generally unenforceable, and we're finding them less and less in employment contracts, new employment contracts as a result, because lawyers who draft those contracts typically know now that the non-compete clauses are often unenforceable, depending on the industry. And so, Mark, why don't you contact us? Let us learn more about your situation. You can contact us at help@employmentlawyer.ca, and we definitely have resources on this topic as well that you can find at employmentlawyer.ca. So, Mark, I hope that answers your question. If you have a follow-up, you could post it in the chat. Now, before we move on to more questions, I want to talk about Twitter again. And I've spoken about Twitter in several other sessions, and that's why I say again. We know that Elon Musk has taken over Twitter. There's been a lot of layoffs as a result, and he's taking a very different approach to running the company. And we know that 2 Canadian executives were laid off around early November from Twitter. Unclear exactly how many people have been terminated or laid off from Twitter. But what we do know is that recently Elon Musk has said, I believe it was mid-November, that he wants everyone to prepare for what he called a hardcore work environment. And if employees want to resign, they're happy, to have them resign, and they would receive 3 months of severance pay. And again, I want to reiterate all the problems associated with that statement. And so, first of all, 3 months severance pay. You can't just have a one-size-fits-all severance package. And I've spoken about this concept in past sessions. So you can't just say any employee who is terminated or resigns is going to get 3 months of severance pay. And the reason why is because, as I've discussed earlier in this session, severance pay is a calculation based on your particular circumstances. Every employee looks different, right? And if you are a certain age, you're going to get more or less severance pay than somebody else, than one of your colleagues, depending also on your position, how much you were earning, how long you worked for the company, how easily you can reemploy. All of these are factors that are used to calculate and determine what a reasonable and fair amount of severance pay is for you. So to make a statement that everyone's going to get 3 months is certainly problematic. 3 months could be more than what a person is usually entitled to, depending on their circumstances. And in many cases, it's much less than what they're entitled to. So that's the first statement that was problematic. Another problematic statement is that what he alluded to as a hardcore work environment. And so that is a situation where we are potentially dealing with a constructive dismissal. Your employer cannot just change the work environment. Again, that would be a substantial change to the fundamental terms of your employment. If there's going to be now what he calls a hardcore work environment, where people essentially are left with a decision of, can I work in this environment or should I quit? That is very problematic. And that in and of itself can be a constructive dismissal. And so if you have been dealing with this, either working for Twitter or in any other company, because it's not uncommon that this is happening, it's another way of calling it is colloquially quiet firing. It's where your employer is putting you in a situation where they want you to really resign. And the reason why they want you to do that is so that they don't have to pay you severance. And so they're changing the terms of your employment. They're changing the work environment so that you feel, I can't work here anymore. And therefore you resign. And so don't let that happen to you. Contact us, learn more about this at employmentlawyer.ca. And if you want to set up a consultation or ask us more questions, contact us at help@employmentlawyer.ca. And another new piece of information we have from Twitter is that we know that 2 former Twitter employees are suing based on discrimination. And I talked about the concept of discrimination earlier in this live session. But the lawsuit, it's actually from the US, it's out of San Francisco, I believe, is that female staff are alleging that they've been disproportionately targeted with these layoffs and terminations from Twitter. And there's been more females who have been terminated than males at the company. And so, as you know, Canada has laws also dealing with discrimination, possibly even more protective than the US. And gender is certainly a protected ground. And so if you're facing a situation where you believe that you are being discriminated against as a result of your gender or any other reason, then you should absolutely inquire with us, learn more about your rights, and potentially pursue those rights if necessary. And organizations in Canada that deal with these issues are the Human Rights Tribunal in Ontario, the Alberta Human Rights Commission, and the British Columbia Human Rights Tribunal. So they're responsible for adjudicating and hearing these discrimination claims, and we can absolutely assist you with that. Okay, let's move on. We have a little bit more time. So let's move on to a question on Facebook from Elaine. So Elaine asks, I've been offered a new job, but I'm nervous about leaving my current position due to the recession. If I'm let go soon after I start this, what would my options for severance be? Okay, so great question, Elaine. I understand your hesitation as a result of the recession. We never know what's happening and what the job market might be. So it depends on really, are you starting a new job at the same company or a different company? I'm going to assume you mean a different company. And so if you're let go from your current employer, you're owed full severance pay. Now, we do have a concept in Ontario where if you find other jobs during the period that you're owed severance, that might impact your severance pay claim. And that's called mitigation. Very important legal concept, and it applies to employees who've been terminated and who are owed severance pay. And so mitigation means that you might have reduced your severance pay potentially if you find a very comparable job. So if this new job that you have is comparable to your previous job in terms of your pay, your duties, the geographic location of the new position, then your severance pay from your previous employer could be impacted. But in many cases, it's not impacted because every situation is different. And so in order to determine what your severance pay might be, use our Pocket Employment Lawyer tool, use a severance pay calculator, and set up a consultation with us. And we'll let you know how to deal with this issue, how to go about leaving your position and potentially going to the new position, what severance pay you're looking at. If you're dealing with a situation where you might mitigate your damages, how that works, we're happy to answer all of those questions for you. Okay, we have limited time left. And we have a follow-up comment from Mark. He asked a question earlier about non-compete clauses. So Mark follows up by saying, I'm in the tech industry and I assume it's because of proprietary knowledge. Contract says I have an 8-month hold on working for a competing company if I leave. Yeah, Mark, so that might very well be illegal. So, and I understand how that's giving you problems during the 8 months after you leave the company. So again, let's talk further about your situation. Contact us at help@employmentlawyer.ca. We'll set up a consultation with you, and I will assist you, or one of my colleagues will assist you further. So thank you for joining us. Happy holidays if I don't see you again before then. I hope you're all well and you stay warm and healthy. Take care.